Pleasure to welcome Michael Zimmerman to our program. Mr. Zimmerman is a children's lawyer with the Vancouver firm Lindsay Kenney LLP. Michael, good morning and welcome to the show, sir.
Good morning, Stirling. Thank you for having me today.
Well, great to have you with us. And according to the Government of Canada's website at justice.ca, there are two descriptions of representation for children in legal terms. One is an advocate or child's lawyer, and that person is under an obligation to put forward the child's preference and wishes, regardless of whether they're in the child's best interest. And the other one is a litigation guardian representing the best interests of the child in court. Although they listen to the child's instructions, they can completely disregard the instructions if they think they're not in accordance with the child's best interest. Which of the two are you, Michael?
So there's pros and cons to both method of legal representation. Typically, when someone is looking to involve a children's lawyer, that can happen in two ways. It can happen by court order. And in those circumstances, depending on what the situation is involving that child and that family, there could be a discussion with the judge who is making the order on what the judge, who is the final decision maker, determines would be the more appropriate mode of legal representation for that specific child.
Okay.
The other way that a children's lawyer could become involved could be through agreement through the two parents. And so in that circumstance, the lawyer should have a discussion with the parents to really identify what is the issues in dispute that the parents are trying to resolve, and then have a discussion with those two parents about what the two different modes of representation are, and obviously have that discussion with the child.
So, I'm sorry, Michael, I'm just curious about one other thing, one other component or one other step in the process. Before going to trial and the big, nasty, expensive legal fight that is involved with that, most parents are directed towards a mediation process, which sees lawyers from both sides sitting down without a judge, but working something out. In those mediation meetings, is there also someone representing the interests of the child in the discussion, or do the lawyers for both parties take that under consideration?
Hopefully, since this is the area that I practice in, it is becoming more and more common that a children's lawyer would participate in mediations, because oftentimes what we see, and often at no fault of either the parents' lawyers or the parents themselves, is they come to an agreement about a schedule, in particular if it's an older child, let's say 15. If no one has spoken with that 15-year-old, the parents may inadvertently come to an agreement about a parenting schedule that the 15-year-old does not think is something that is going to work for them, and that can result in a lot of conflict, and even that 15-year-old refusing to abide by that schedule. So what we are seeing, though, is a recognition by family law lawyers who represent parents that there is a role for a children's lawyer at the mediation table, so they can put forward that child's views and preferences as it relates to that parenting schedule. So absolutely there is a role, but if it is just the parents' counsel, typically it is not their job to be the ones talking to the child and putting forward their views and preferences, because that could be viewed as coming from a party who is not neutral.
Right. We had an interesting discussion with an animal rights lawyer on our show yesterday, Michael, talking about these nasty court spats over pets, for crying out loud. and that's a very different category, but nonetheless, the acrimony isn't. The divorce process can be very hurtful because somebody in that relationship has been hurt, maybe both parties in some cases. But in the middle of all of this, Michael, are the children. What, as a children's lawyer, when you see these acrimonious situations playing out and it's really hostile and you're dealing with the little person in the middle, how do you counsel those children?
Absolutely. So one thing that has taken a while for children's lawyers to become more common is the perception that children are vulnerable victims and should not be included in any of the discussions around their parent separation. Research has now shown that that is not true. And research has shown that children do want to have a voice. They want to know what's happening. Obviously, that needs to be done carefully by a trained professional who can do it based on that specific child's maturity and age and stage of development. But what I have seen happen time and time again is, particularly with parents that are involved in high conflict disputes is if you have a neutral person who is there specifically to represent your child and put forward your child's concerns, oftentimes that can help the two parents move away from that entrenched state of conflict to refocus matters on their child, and it often results in resolutions outside of the court system.
Interesting stuff. Do judges sometimes just go, okay, I've had enough of the battle. Don't let's not lose sight of the fact that there are children involved in this. Enough already. Do you hear that from time to time?
Absolutely, and the international, federal, and provincial laws all around the family. So in BC, we have the Family Law Act, and then federally, the Divorce Act. Both of those two pieces of law state that the court and also the parents, every single step of a proceeding in court has to be done in accordance with the child's best interest. And since the judge is that final decision maker and gatekeeper, they do have an obligation to ensure that if parents are not acting in the best interest of the child, that appropriate mechanisms are put in place to shield that child from conflict and to ensure that their best interests are protected and promoted.
Yeah, and of course we do have the Family Law Act, as you just pointed out, Michael, and that's fairly recent compared to other provinces in Canada. It's not that old, and it did cause some significant changes, particularly with regards to the emphasis on the interests of the child dominating, right?
That is correct. So in 2013, the Family Law Act came into force, and it replaced a previous act. And that act was one of the most modernized pieces of legislation in Canada when it comes to family law legislation. And there are many different mechanisms built into that act about how a child can be heard and the obligation of decision makers as well as parents to consider children's views and preferences before any orders are made in court or any agreements are signed between two parents.
Michael, as I understand it, by law, in BC, a child is anyone under 19. But there's a big difference in a 19-year-old and a 9-year-old. So when it comes to understanding or soliciting the point of view of the child, the feelings, the sentiments, and all the rest of it, what is an age at which the court will hear from a child in person, or at least acknowledge that the child's resolve through their lawyer? Is there an age is there a cutoff point?
I'm going to take you back to your first question, Stirling. So when you had given me the examples of the two ways that children can be represented by a lawyer, the advocate model and the litigation guardian,
mm-hmm.
On the advocate model, that child needs to be able to instruct counsel. So they need to be able to understand why a lawyer is involved and the implications for having a lawyer. So in those circumstances, there is no magic age. Oftentimes there is a perception in society that it's 12 years old. That is not true. It is not written anywhere.
Oh, okay.
It is based on a child's age and stage of development. So at times when I'm representing children, a 9-year-old might be able to understand the implications of having a lawyer, but a 13-year-old may not.
Right. Okay. So it's an individual case-by-case situation.
That is correct. And then in the other model you had said, Stirling, the litigation guardian model, you don't need to have capacity to instruct your lawyer in that model. So in that model, children, typically younger children, say 6 or 7, who may not be able to instruct counsel, could still have their voice heard, just not based on that full lawyer model that most of us would be familiar with.
Interesting stuff, Michael. Grateful for your time on a Sunday morning. Final question to you, sir. How's business? Post-pandemic or during the pandemic, did business go up or down?
Unfortunately, in family law and children's law, when society is experiencing struggles, we tend to see an uptake in separations, divorce, and also conflict. So with the pandemic, I personally have noted a marked increase in activity, unfortunately, within the family law system. So that's just an unfortunate result.
Interesting stuff. Michael, pleased to have found you, sir. We'll talk again. Grateful for your time, as I mentioned earlier. Thanks so much for this.
Thank you, Stirling. It was great to be with you this morning, and I hope you enjoy the rest of your day.